I express my gratitude to the Honorable former Chief Minister of Tamil Nadu, Puratchi Thalavi Amma, for being there in this August House to speak on the Factories Amendment Bill 2016. Sir, the Factories Amendment Bill 2016 was passed by Lok Sabha in August 2016. The Comprehensive Factories Amendment Bill 2014 was initially introduced in Lok Sabha in 2014 and later referred to the Parliamentary Standing Committee. The Standing Committee in the report raised serious objections to many of the proposed amendments, while welcoming some of the amendments. Since the 2014 bill saw no movement, after that the government decided to come out with the present bill, amending just two sections of the Factories Act, section 64 and 65. Welfare of the labour, including conditions of work, is a subject of concurrent list of our constitution, which means that both centre and state can make laws on the subject. The Factories Act 1948 itself is a central piece of legislation, but section 64 and 65 provided certain rule-making powers exclusively to states. Now this is being amended to empower the central government and also make rules on those subjects. Such overlapping of powers can result in conflagrations of and would be against the principle of cooperation and federalism. Though this amendment, the government could impose reforms on states as well as by itself making rules if the state is not taking initiative. Section 64 provided that a state can prescribe rules to set the overtime limits, but such overtime should not exceed 50 hours in a quarter, a period of 3 months. This is being amended to say what now the center or the state can prescribe the rules governing overtime limits, but the overtime limit cannot exceed 100 hours in a quarter. The limit has been expanded to 50 to 100 hours, but further any rule made under the section was to be in operation for 5 years only, but now the rules made under this section can be in operation for an indefinite period of time. Section 65 earlier provided that state can relax certain conditions like period of work under some circumstances, and to enable the factory or factories to deal with an exceptional press of work. It can be prescribed overtime limits which must not exceed 75 hours in a quarter. Now the center is as well as state can make rules in this regard and can prescribe an overtime limits which cannot exceed 115 hours. The limit has been expanded from 75 hours to 115 hours. The bill further adds a provision enabling the central and or the state government and even the chief inspector with the prior approval of the state government to increase the number of overtime hours to 125 hours in a quarter of public interest. The Parliamentary Standing Committee reviving the 2014 bill had taken serious objection to the amendments to section 64 and 65 and had observed that such a move is likely to negatively affect the employment generation. The committee recommended that rather than increasing overtime limits across the factories, those industries and seasonal factories can be identified where overtime is inevitable and rules by made separately for those. It is not clear that exceptional press of work exists or what public interest will be served or even how employment generation will be enhanced by increasing the overtime limits. Should powers to be given to both central and state governments to make rules on the same subject, considering that it can be lead to confrontation. No, do the present circumstances require increasing the limit of overtime for workers across all industries? Is such a change with the stated objective of enhancing employment opportunities as mentioned in this bill itself? What public interest would be served by increasing the overtime limits? Piloting the bill, the Honorable Minister for Labour, Mr. Bandari Dattaya, had said that the changes in the new law would enable workers to work more and earn more. contemplating that the bill safeguard workers' interest. The total number of work hours is in a day, it will not exceed 10, and the total hours of work in a week after including the overtime should not be exceed 60. Overtime is the only an opportunity. The proposed amendment is not in conflict with the ILO norms and all provisions relating to the daily or weekly hours. Total number of overtime should not exceed 100 hours in a quarter. The current rules provide for overtime of 50 hours in a quarter, while the ILO provides for upper limit of 144 hours. The Honorable Minister has said that the government is going with innovative method in creating employment opportunities, and large number of women workers will also get additional work. The proposal to increase the overtime hours is not at all mandatory. It is up to the workers to decide. It is not compulsory upon him or her. It is an incentive to get double wages. Among other charges, the bill also allows overtime up to 125 hours per quarter in public interest and empowers central and the state government to exempt rules with regard to overtime working hours. There shall be no compromise on the safety and working condition of workers, and the bill should facilitate increase in employment generation in the manufacturing sector. The bill should not be encouraging upon the rights of the states and against the federal structure of the country. The government has proposed the amendments in the bill are based on the changes of the manufacturing practices and the technologies, ratification of ILO conventions, judicial decisions, recommendations of various committees and decisions taken in the conference of the Chief Inspector of Factories.
Please conclude. Please conclude.
The bill amends and specifies the definition of the factory, hazardous processes, manufacturing process, and also substances and disability. According to the present bill, the state government's power to make rules will be restricted to matter where the central government does not have such powers, and the central government may frame rules in consultation of the state governments to bring uniformity in the areas of occupational safety with the help of the bill. Also, bill seeks to permit the central or state governments to prescribe the authorized officers and the amount for compounding of the certain offences before commencement of the prosecution.
Thank you. Thank you.